Start. At the initial stage of framing of a charge, the court is concerned not with proof but with a strong suspicion that the accused has committed an offense which, if put to trial, could prove him guilty. Stop. All that the court has to see is that the material on record and the facts would be compatible with the innocence of the accused or not. Stop. The final test of guilt is not to be applied at that stage. Stop. We may refer to the well settled law laid down by this court in State of Bihar versus Ramesh Singh 1997 4 SCC 39 para. Under section 226 of the code, while opening the case for the prosecution, the prosecutor has got to describe the charge against the accused and state by what evidence he proposes to prove the guilt of the accused. Stop. Thereafter comes at the initial stage the duty of the court to consider the record of the case and the documents submitted therewith and to hear the submissions of the accused and the prosecution in that behalf. Stop. The judge has to pass thereafter an order either under section 227 or section 228 of the code. Stop. If the judge considers that there is no sufficient ground for proceeding against the accused. Stop. He shall discharge the accused and record his reasons for so doing as enjoined by section 227. Stop. If, on the other hand, the judge is of the opinion that there is ground for presuming that the accused has committed an offense which is exclusively triable by the court, he shall frame in writing a charge against the accused as provided in section 228. Reading the two provisions together in juxtaposition as they have got to be, it would be clear that at the beginning and at the initial stage of the trial, the truth, veracity, and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged. Stop. Nor is any weight to be attached to the probable defense of the accused. Stop. It is not obligatory for the judge at that stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not. Stop. The standard of test and judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under section 227 or section 228 of the code. Stop. At that stage, the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction. Stop. Strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial. Stop. But at the initial stage, if there is a strong suspicion which leads the court to think that there is ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. Stop. The presumption of the guilt of the accused, which is to be drawn at the initial stage, is not in the sense of the law governing the trial of criminal cases in France, where the accused is presumed to be guilty unless the contrary is proved. Stop. But it is only for the purpose of deciding prima facie whether the court should proceed with the trial or not. Stop. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. Stop. An exhaustive list of the circumstances to indicate as to what will lead to one conclusion or the other is neither possible nor advisable. Stop. We may just illustrate the difference of the law by one more example. Stop. If the scales of pen as to the guilt or innocence of the accused are something like even at the conclusion of the trial, then on the theory of benefit of doubt, the case is to end in his acquittal. Stop. But if, on the other hand, it is so at the initial stage of making an order under section 227 or section 228, then in such a situation ordinarily and generally the order which will have to be made will be 1 under section 228 and not under section 227. Para. Having discussed the scope of jurisdiction under these provisions, that is section 397 and section 482 of the code, and the fine line of jurisdictional distinction, now it will be appropriate for us to enlist the principles with reference to which the courts should exercise such jurisdiction. Stop. However, it is not only difficult but it is inherently impossible to state with the precision such principles. Stop. At best, and upon objective analysis of various judgments of this court, we are able to cull out some of the principles to be considered for proper exercise of jurisdiction, particularly with regard to quashing of charge, either in exercise of jurisdiction under section 397 or section 482 of the code or together, as the case may be. Para. Though there are no limits of the powers of the code under section 482 of the code, but the more the power, the more due care and caution is to be exercised in invoking these powers. Stop. The power of quashing criminal proceedings, particularly the charge framed in terms of section 228 of the code, should be exercised very sparingly and with circumspection, and that too in the rarest of rare cases. Para. The court should apply the test as to whether the uncontroverted allegations as made from the record of the case and the documents submitted therewith prima facie established the offence or not. Stop. If the allegations are so patently absurd and inherently improbable that no prudent person can ever reach such a conclusion, and where the basic ingredients of a criminal offence are not satisfied, then the court may interfere. Para. The High Court should not unduly interfere. Stop. No meticulous examination of the evidence is needed for considering whether the case would end in conviction or not at the stage of framing of charge for quashing of charge. Para. Where the exercise of such power is absolutely essential to prevent patent miscarriage of justice and for correcting some grave error that might be committed by the subordinate courts. Even in such cases, the High Court should be loath to interfere at the threshold to throttle the prosecution in exercise of its inherent powers. Para. Where there is an express legal bar enacted in any of the provisions of the code or any specific law in force to the very initiation or institution and continuance of such criminal proceedings, such a bar is intended to provide specific protection to an accused. Para. The court has a duty to balance the freedom of a person and the right of the complainant or prosecution to investigate and prosecute the offender. Para. The process of the court cannot be permitted to be used for an oblique and ultimate ulterior purpose. Para. Where the allegations made and as they appeared from the record and document annexed therewith to predominantly give rise and constitute civil wrong with no element of criminality, and does not satisfy the basic ingredients of a criminal offense, the court may be justified in quashing the charge. Stop. Even in such cases, the court would not embark upon the critical analysis